To my channel Knowledge of Law with Jyoti. In this video lecture we will discuss about the Indian Evidence Act. This is the introductory part of this act. The Indian Evidence Act is the Act number 1 of 1872 and it was drafted by Sir James Stephen. It was enacted on 15th March 1872 and commencement date of this act from 1st of September 1872. It contains total 167 sections and 11 chapters under 3 parts. Part 1 deals with relevancy of facts, Chapter 1, and Chapter 2. Chapter 1 preliminary, Chapter 2 relevancy of facts from Section 5 to Section 55. Part 2 deals with on proof and contains Chapter 3, 4, 5, 6. Chapter 3 from Section 56 to 58. Chapter 4 of oral evidence, 2 sections, Section 59 and Section 60. Chapter 5 of documentary evidence from Section 61 to Section 90A. Section 4 exclusion of oral by documentary evidence from Section 91 to Section 100. Now the last part of this Act, Part 3, deals with production and effect of evidence from contains Chapter 7, 8, 9, 10 and 11. Chapter 7 deals with burden of proof from Section 101 to 114A. Chapter 8 deals with estoppel, 3 sections, Section 115, 16 and 17. Chapter 9 witnesses from Section 118 to 134. Chapter 10 deals with examination of witnesses, Section 135 to 166. Last chapter of this Indian Evidence Act deals with improper admission and rejection of evidence. Have only one section, 167. No new trial for improper admission or rejection of evidence. That's all. And Section 1 deals with short title, extent and commencement, which I discussed. And Section 2 is repealed by the Repealing Act of 1938. Section 3 interpretation clause, in which various definitions given: court, fact, relevant, facts in issue, document, evidence, proved, disproved, not proved, India. And Section 4 may presume, shall presume and conclusive proof. This definition of Section 3 and Section 4 we will discuss in next part. Let's see overview of the section. Chapter 2 of the relevancy of facts. Section 5 evidence may be given of facts in issue and relevant facts. Section 6 relevancy of facts forming part of same transaction. Section 7 facts which are the occasion, cause or effect of fact in issue. Section 8 motive, preparation and previous or subsequent conduct. Section 9 facts necessary to explain or introduce relevant facts. Section 10 things said or done by conspirator in reference to common design. Section 11 when facts not otherwise relevant become relevant. Section 6 also known as res gestae. And Section 9 test identification parade. And Section 11 plea of alibi. Section 12 in suits for damages facts tending to enable court to determine amount are relevant. Section 13 facts relevant when right or custom is in question. It deals with customs. Section 14 facts showing existence of state of mind or of body or of bodily feeling. Section 15 facts bearing on question whether act was accidental or intentional. Section 16 existence of course of business when relevant. Section 17 defined admission. Section 18, admission by party to proceeding or his agent, by suitor in representative character, by party interested in subject matter, by person from whom interest derived. Section 19 deals with admissions by persons whose position must be proved as against party to the suit. Section 20, admissions by persons expressly referred to by party to suit. Section 21, proof of admissions against persons making them and by or on their behalf. Section 22, when oral admissions as to contents of documents are relevant. Section 22A, when oral admissions as to contents of electronic records are relevant. Section 23, admissions in civil cases when relevant. Section 24, confession caused by inducement, threat or promise when irrelevant in criminal proceeding. On Section 25, confession to police officer not to be proved. Section 26, confession by accused while in custody of police not to be proved against him. Section 27, how much of information received from accused may be proved. Section 28, confession made after removal of impression caused by inducement, threat or promise relevant. Section 29, confession otherwise relevant not to be become irrelevant because of promise of secrecy, etc. Section 30, consideration of proved confession affecting person making it and others jointly under trial for same offence. Section 31, admissions not conclusive proof but may operate as estoppel. Section 32 is also important. Cases in which statement of relevant facts by person who is dead or cannot be found, etc. is relevant when it is relates to the cause of death, cause of business, or against interest of maker, or gives opinion as to public right or custom, or matters of general interest, or relates to existence of relationship, or is made in will or deed relating to family affairs, or in document relating to transaction mentioned in section 13 clause A, or is made by several persons and expresses feelings relevant to matter in question. Section 33, relevancy of certain evidence for proving in subsequent proceedings the truth of facts therein stated. Section 34, 35, 36, 37, 38, statements made under special circumstances. How much of statement is to be proved deals with section 39. Judgments of courts of justice when relevant, such as section 40, previous judgments relevant to bar a subsequent suit or trial. Section 41, relevancy of certain judgments in probate, etc. jurisdiction. Section 42, section relevancy and effects of judgment, order or decrees other than mentioned under section 41. 43, judgments, etc. other than section 40, 41, 42 when relevant. Section 44, fraud or collusion in obtaining judgment or incompetency of court may be proved. Opinion of third person when relevant deals under section 45 to 51. Section 45, opinions of experts. 45A, opinion of examiner of electronic evidence. 46, facts bearing opinion of experts. 47, handwriting. Section 47A, opinion as to digital signature. 48, opinion as to existence of right and customs. 49, usages and tenants. 50, on relationship. 51, grounds of opinion. And character when relevant deals under section 52 to 55. 52 deals with civil cases, character to be proved, conduct imputed irrelevant. In civil cases, character to be proved is irrelevant. Section 53, in criminal cases, previous good character relevant. Section 53A, evidence of character or previous sexual experience not relevant in certain cases. 54, previous bad character not relevant except in reply. Section 55, character as to affecting damages. Part 2 on proof, chapter 3, facts which need not be proved. Section 56, fact judicially noticeable need not be proved. Section 57, facts of which court must take judicial notice. 58, facts admitted need not be proved. 59, proof of facts by oral evidence. 60, oral evidence must be direct. 61, proof of contents of documents. 62, primary evidence. 63, secondary evidence. 64, Proof of documents by primary evidence. 65 cases in which secondary evidence relating to documents may be given. 65A special provisions as to evidence relating to electronic evidence. 65B admissibility of electronic records. 66 rules as to notice to produce. 67 proof of signature and handwriting of person alleged to have signed or written document produced. 67A electronic signature का proof. 68A proof of execution of document. 69 where no attesting witness found, its proof. 70 admission of execution by party to attested document. 71 proof when attesting witness denies the execution. 72 proof of document not required by law to be attested. 73 में comparison of signature, writing or seal with others admitted or proved. 73A proof of as to verification of digital signature. Public documents 74 to 78. 74 defined public documents. 74 defined public documents. 75 private documents. 76 certified copies of public documents. 77 proof of documents by production of certified copies. 78 proof of other official documents. Now the presumption as to documents part. 79 onwards. 79 presumption as to genuineness of certified copies. 80 presumption as to documents produced as record of evidence. 81 presumption of gazette, newspaper, private acts of parliament and other documents. Presumption as to gazettes in electronic forms. Presumption as to document admissible in England, not important section. Presumption as to maps or plans, section 83. Section 84 presumption as to collection of laws and reports of decisions. Section 85 presumption as to power of attorney. 55A electronic agreements. 55B electronic records and electronic signature. 85C presumption as to electronic signature certificates. 86 certified copies of foreign judicial records. 87 books, maps, charts. 88 telegraphic messages. 88A electronic messages. 89 presumption as to due execution etc. of documents not produced. 90 section presumption as to documents 30 years old. 90A electronic records 5 years old. Exclusion of oral by documentary evidence, section 91 evidence of terms of contract, grants or and other dispositions of property reduced to form of document. 92 exclusion of evidence of oral agreements. 93 exclusion of evidence to explain or amend ambiguous document. 94 exclusion of evidence against application of document to existing facts. 101 burden of proof. 102 burden of proof lies. 103 burden of proof as to particular fact. 4 burden of proving fact to be proved to make evidence admissible. 105 burden of proof that cause of accused comes within exceptions. 106 especially within the knowledge of burden of proving the fact. 107 burden of proving death of person knowing to have been alive within 30 years. 108 में 7 years a person is alive who has not been heard. Section 109 burden of proof as to relationship in the cases of partners, landlord, tenant, principal and agent. 110 as to ownership. 11 proof of good faith in transaction where one party is in relation of active confidence. 111A presumption as to certain offences. 112 birth during marriage, conclusive proof of legitimacy. 13 proof of cessation of territory. 13A presumption as to abatement of suicide by a married woman. 13B 113B presumption as to dowry death. 14 court may presume existence of certain facts. 14A presumption as to absence of consent in certain prosecution of for rape. 115 defines estoppel. 16 estoppel of tenants and of licensee of person in possession. 117 estoppel of acceptor of bill of exchange, bailee or licensee. 118 who may testify. 19 witnesses unable to communicate verbally. 20 parties to civil suit and their wives or husband or wife of person under criminal trial. 121 judges and magistrate next communication during marriages. 122 123 evidence as to affairs of state. 124 official communications. 125 information as to commission of offences. 126 professional communications. 127 section 126 to apply to interpreters etc. 128 privileged not waived by volunteering evidence. 129 confidential communications with legal advisor. 130 production of title deeds of witness not a party. 133 accomplice. 34 number of witnesses. 135 production of order of production and examination of witnesses. 36 judge to decide as to admissibility of evidence. 137 define examination in chief, cross examination and re-examination. 138 deals with order of examination or direction of re-examination. 39 cross examination of person called to produce a document. 140 witnesses to character. 141 leading questions. 142 when they must not be asked. 143 when they must be asked. 144 evidence as to matters in writing. 145 cross examination as to previous statements in writing. 146 questions lawful in cross examination. 151 indecent and scandalous questions. 152 questions intended to insult or annoy. 154 questions by party to his own witness. 155 impeaching credit of witness. 156 questions tending to corroborate evidence of relevant fact admissible. 157 former statements of witness may be proved to corroborate later testimony as to same fact. 159 refreshing memory when witness may use copy of document to refresh memory. 161 right of adverse party as to writing used to refresh memory. 162 production of document or translation of documents. 165 judges power to put questions or order production. 166 power of jury or assessors to put questions. Last section 167 no new trial for